Imagine you buy a new computer. You order it by phone, it arrives at your door, you plug it in, and it works great. Welcome to Once Upon a Case, because the law isn't just for lawyers, it's for everyone. A week later, you learn there's a contract in the box that says, if you keep the computer, you agree to arbitrate any disputes. No courtroom, no jury, no class action. Is that even a contract? In 1997, a case called Hill v. Gateway 2000 said yes. If you keep the product past the return window, you've accepted the contract. Here's what happened. The Hills call Gateway to buy a PC. The box shows up with papers inside, standard terms and conditions. One was a bold arbitration clause. Any disputes go to arbitration unless you return the computer within 30 days. The Hills keep it. They later sue in federal court over charges and warranties. Gateway says, hold up, you agreed to arbitrate by keeping the machine. The trial court said no. The appeals court, 7th Circuit, Judge Easterbrook, said yes. Why? Because contracts aren't just signed on a dotted line. Under the UCC, you can form a contract by conduct. The idea, money now, terms later. When you order by phone, you don't get a stack of legal papers read to you. Seller can send product with terms. You can accept by using it, or reject by returning within the stated period. The court leaned on ProCD versus Zeidenberg, shrink-wrap terms in software boxes. Same logic. Terms inside, chance to read at home, return if you don't like the deal. Keep it beyond the window? That's acceptance. But what about arbitration specifically? The Federal Arbitration Act. Arbitration agreements are generally enforceable. The Hills said they never bargained for arbitration. The court, you did, via the return policy. You had a clear way out. You chose to keep the computer. This raised, when are in the box terms fair? Court's pragmatic answer. Buyers must get notice a reasonable chance to read the terms and an easy way to return, otherwise unconscionable. Some courts later flagged harsh arbitration fees or procedures. One case found fee structure unconscionable. Gateway adjusted. Critics. This buries consumers in fine print, forcing arbitration and blocking day-in-court rights. Supporters. Realistic. Commerce needs standard terms and an opt-out by returning. Since then, courts and the Supreme Court generally favor arbitration clauses when the mechanism for agreement is clear. So, takeaways. If you buy something that arrives with terms, paper, email, a link, check for return windows tied to acceptance. Arbitration clauses often live there. They usually mean no court, faster timelines, limited discovery, no class actions. If you don't agree, return the product within the stated period. That's your exit ramp. Why it matters. Contract formation isn't just signing. It's how you behave after you get the terms. In Hill versus Gateway 2000, keeping the computer after 30 days was the signature. Click wrap, I agree buttons. Browse wrap, terms behind a link. Post-purchase terms in emails or boxes. Sneaky or hard-to-find terms or no real way to say no are more likely to fail. Hill versus Gateway set the template. Companies can send terms, try it, read them, send it back if you don't like them. Consumers can decide by returning or keeping. Acceptance by retention. So next time a box shows up, don't toss the papers. Your decision to keep what's inside might be the loudest I agree you ever make. Thank you for watching. If you enjoyed this case, please follow along for more. See you on the next episode.